Welcome to Reduce Headaches, the Residential Remodeler's Guide to Contracts, a webinar brought to you by AIA Contract Documents. Thank you for joining us today. We do have a few administrative items before we get started. Just a disclaimer here, this program and accompanying materials are provided for general informational purposes only. The information is not provided as legal advice. So we always recommend that you contact your legal counsel. The presentation is provided by U.S. and international copyright laws. Reproduction, distribution, display, and use of the presentation without written permission is prohibited. With that, I'd like to go ahead and turn it over to one of our presenters, Michael Bell. Michael, take it away.
Thank you, Marika. Good afternoon. Thank you for joining us for our presentation today. I am Michael Bell. I am both an architect and an attorney. I spent 6 years as a law student and an attorney, and otherwise for 30 years I've practiced architecture as principal of Bell Architecture in New Orleans. My work is almost exclusively residential. As an architect lawyer, I've remained fascinated with how design and construction interrelate with the laws and contracts. And that led me to the American Institute of Architects Documents Committee. Last year, I wrapped up my 13-year tenure, and I chaired that committee for 2 years. And there I worked on all kinds of design and construction contracts. But contracts for residential projects were my primary and my most my beloved focus. Next, Marika.
Well, hi, I'm Marika Snyder, and I am an architect and a professor. I teach at the University of Memphis, but I also have a small firm out of Dayton, Ohio, which I've had since 2003. Most of the work that I do is design build, and so I'm fairly involved from the construction side. And then going forward, I've done a variety of project types, but I'm focusing more on historic preservation, which by its very nature becomes a remodeling and rehabilitation type project. I also was on the construction, I am on the construction, the AIA Contract Documents Committee with Michael, and we worked together on the residential suite. And then I've also worked on the interiors project, and I'm in year 8 of 10. Thanks.
So AIA has published standard documents and forms for 130 years. One of the great things about how we write these documents at AIA is that stakeholders participate in the process. That includes contractors, owners, and architects, not just attorneys. These AIA documents have been interpreted by the courts and evolved over the years to reflect our changing world of design and construction, to where today we have AIA has nearly 200 documents and forms that we publish. Next. The industry does treat them like a standard. That is our goal, and the industry does. They are pretty standard. We try to be fair and balanced when we write them. Fair and balanced between the various parties to the contracts. Try to balance competing interests of the various parties to the agreements, and put risk where it's best managed. Next slide from Marika.
So there's a few different ways that we can manage risk, and there are a few things that are specific to residential construction and remodeling. Next. Owners, there's a lot of risk around owners themselves because they care very deeply about their homes. They're very invested personally, not just financially. And they often live on the site, and so they're living with the construction, or they visit it very frequently. And they're often not familiar with the construction processes. And so it becomes kind of a situation where they're watching the sausage be made, and maybe it's a little bit too much detail that they didn't necessarily need to know. And so there's heightened stress overseeing all of the processes. And they may also think that perfection is the standard of care. And so that puts a lot of stress onto the builders. The risks in residential remodeling are also because it's more complex. There's a lot of difficulty that goes into integrating the new construction and the old and matching the new and the old together. And then unforeseen conditions happen in every project where something that you could not know until you opened up that wall occurred. And so that increases the risk of a project. And then the fact that there's limited use of the site, that you have to actually be very, that's very controlled what you can use and the hours, so that you don't damage in existing construction or household goods or other things, as well as allow for the free movement throughout for other purposes in the house. And these things can result in delays or increased costs and disputes. So we would like to avoid risk, but we cannot. So one method is to accept risk that's appropriate, especially for appropriate compensation. The second is to mitigate the risk, and one of those ways is through carrying insurance. And then sometimes the best way to deal with risk is to transfer it to the party that can best control it. So contractually, we transfer the risk to the owner for providing an accurate survey. So if anything happens, that there's a problem with the survey, that becomes the owner's responsibility because it's their property and they are best able to control that. Or, for example, if an owner doesn't make timely decisions, that impacts the cost and the schedule. And so the owner should be the one to bear the risk of untimely decisions. Now, one of the ways to mitigate risk is to establish appropriate expectations. And many disagreements center around these issues, like the payment schedule, when is it due, how long do parties have before they have to pay, the start and end dates, and then jurisdictional requirements, which may be out of the control of the builder, but have to be followed. And then site access, often, particularly in residential remodeling, is very important because there may be certain hours, there may be just for the convenience of the people living there, or if it's in sound, there may be issues with sound, with neighbors, with HOAs, and also limited space to stage materials. Then changes in the work, it's very important to establish how those will be dealt with, and so that, especially so that the builder will be compensated fairly in terms of fees or in times of schedule. And then, of course, warranties and termination are important as well.
So AIA recently published this document that Marika and I worked on with some other folks, entitled A113, the standard form of agreement between owner and contractor for remodel of a single-family home. We developed it specifically for a single-family residential remodeling project. And we're going to take a dive into the A113, and you can go back to the other slide or for the moment. We'll take a dive into the A113 and review its major provisions. In doing so, we hope to illustrate some principles of managing risk in these types of projects, in particular how contract provisions can help to mitigate those risks. I'm looking here at the title of the A113. I want to add a word about agreements. AIA prefers the kinder and gentler term agreement to contract, but we'll both use contract and agreement interchangeably. They're really the same thing. Next. So the AIA A113 addresses construction of a remodeling project. It does not address where the design came from. You know, maybe an architect or draftsman provided it, maybe the contractor provided it, maybe the owner sketched it up. But this agreement is really designed for a simple project. It's not geared toward a major addition or total renovation or multifamily or other less single-family residential type of projects where codes get to be even more of a factor. It may seem long at 7 pages. Everybody always wants contracts to be shorter, but as you'll see, it's important to address in your contract many things. for a more extensive project, you'll want an even more robust agreement than what you'll find in this 7-page agreement. So as we developed this document, in my mind, I pictured a project costing, $100,000 or so, but that was sort of a shorthand for the types of projects that this document was about. But I'd hasten to add that you really should consider the complexity and other risks, and not just the cost of the project when considering the appropriateness of a particular contract. So in A113, we address risks that arise in these types of remodeling projects, and we addressed eventualities that may never come to pass. But if they do, you'll want your contract to provide for what happens. Some examples of those kinds of things are changes, which are going to happen, discovery of hazardous materials, which we hope doesn't happen, termination, which we hope doesn't happen. We'll tell you about several more. So next. So Article 1 in this agreement, provides a list, provides a place to list all that makes up the contract between the owner and the remodeling contractor. This includes this agreement, which is the A113 we're using here. Any drawings and specifications, here's a place to list them. Changes have not yet happened when the agreement is signed, but when they are executed, and they should be executed in writing, they become part of this agreement. Any other documents that might be relevant can be included here. For example, a list of allowances for selections that are to be made. And it all is in this upfront information in Article 1. Next. Also in Article 1, we address that building a home is in some ways different than building a commercial structure in terms of the law. It's pretty much accepted public policy from state to state that buyers of homes need special protection when purchasing a home. Laws vary widely from state to state. Here in Louisiana, we have the New Home Warranty Act, and it is the exclusive remedy for aggrieved homeowners. The law requires that the home builder notify the owner of this remedy and of the procedures that must be followed. But be careful, if you fail to notify the owner of the procedures, you might waive your rights to the defense of claiming that the owner didn't follow proper procedures. So Article 1 here in this document provides a place to fill in or reference the relevant law. So you really need to know what these types of consumer protection laws are in your jurisdiction. In a remodeling setting, there are likely some constraints on performing construction tasks. Marika touched on some of them there. You may not have access to the entire home. Maybe you have access for only certain hours. Owners may require that at the end of the day, utilities are operational again after hours. The owner may want you to surgically remove and store an old fireplace mantle so that it may be reinstalled later. So any of these types of things, it's best to memorialize these points so that they're not argued about later. Here's the place to do that in this fill point. Next. So beyond the owner's requirements, there may be other requirements imposed by outside forces or entities. The homeowners association, if there is one, may have limits, for example, on the hours you can work. Like, for example, not on Sundays, not before 7 a.m. Or there may be historic preservation requirements and not allowing something like vinyl windows. You may reference these types of rules here in Article 1, the initial information article, and you may attach, or you just, you can reference them here and then attach them if they're lengthy. Next. The contractor and owner should have a discussion about consultants and which ones may be required. Is a surveyor required? Does someone need to be hired to draw a floor plan? Do you need an engineer to size a beam and sign off for the permitting office? Here we have a fill point where the contractor's consultants can be named. You can also provide here that the owner is hiring a particular consultant. Next.
So when we move into Article 2, we start to talk about contract time, and the work will commence on a certain date and end on a certain date rather than having to calculate the number of days. What's important about this provision is that there's provisions for delays that are not caused by the builder. So if there are delays that are not the fault of the contractor, the completion date shall be equitably adjusted. So this says this right there in the contract so that it gives you an appropriate extension if there are changes. Next. Then in Article 3, we talk about the sum and the payments. And so it's expected that most of these projects will be a stipulated sum, one cost. If you have a more complicated process of payments such as a cost plus, there may be another contract that's more suitable for that. But here you fill in the amount or the milestones and then the dates, and all of these should add up to the total contract sum. So you might have like foundations on this date, foundations, and then the amount for the foundation, the framing, and the amount for that, and then all of those add up to the total cost. And then you can also fill in for allowances here in the contract, or say see attached and have an attached sheet. So traditional examples would be an allowance for appliances or plumbing fixtures or cabinet hardware, because the selections haven't been made and the prices can be very volatile. Lately, lumber packages have been used as an allowance to manage the risk of escalation. And then if there's other risks that affect the price of the job, they're written in 3.4. And it's also a place that you can fill in other clarifications or exclusions. For example, you might want to clarify that your price does not include the pool, but it does include the deck around the pool. Or that the owner will purchase the appliance, but the contractor will be the one to install the plumbing and the electrical for the appliances. So the contractor will have a number of different types of insurance, such as general liability and automotive, and those listed here. The document contains the standard coverages for each party and then fill points for the limits in each. And then the builder's risk covers the damage to the work while it's under construction. And then there's an other fill point in case the project requires some specialty type of insurance. In some jurisdictions, the contractors are required to post their insurance coverages and licensing information online with the governing agency so that the clients can look that up. So be sure you know what the requirements are in your jurisdiction. Next. And then the owner also has their own insurance that they're required to have. So they would have property insurance that covers the replacement value of their property that might be damaged or destroyed, that's not otherwise covered by the contractor's builder's risk insurance. And this is kind of unique to remodeling because work is often done within an existing structure and with contents that could be damaged. Next. So the contractor responsibilities are listed in Article 5 under general requirements of the work of the contract. And I don't think you'll find any surprises here that the contractor shall perform work in compliance with the licensing agencies and laws and statutes. But what is very important, especially in residential construction, is Section 5.6, where it explicitly says that the contractor shall be solely responsible for and have control over the construction means and methods. And this is important because a lot of times people who are new to construction, especially when it's on their own house, may think that they have the right to tell workers or subs how to do the project. And yet this is the sole, because the contractor is the one that's responsible for the work and taking the risk, the contractor is also the person who has who's allowed to direct, or who has the responsibility to direct that work. And so you want to keep control of that, but also explain that from the outset that who has these responsibilities. And then the warranty states that you'll comply with any statutory warranties and that the contractor warrants to the owner that all of the materials and equipment furnished under the contract will be new unless specified under the contract documents. This seems fairly obvious, but I actually find exceptions to this when I'm doing historic preservation, where we may specify salvaged brick or other materials or old wood that's been reclaimed so that we have the same kind of grain. But unless it's specified, it all needs to be new. And then the warranty also specifies that the work will be free from defects and it'll conform to the contract documents. It does not warrant that it'll be absolutely perfect. Next. But that it will comply with the documents. So permits and fees are the responsibility of the contractor. And you can include this, or you could make an allowance for this in the previous section if there's a lot of variability. And if the inspection falls short, that can be very important in showing that the work was properly performed. So the contractor will provide the owner with the copies of the licenses and fees, of the licenses and permits, to prove to the owner that they have all been approved. And then, as we've mentioned a couple of times, we need to be clear about where and how the site can be used. And so section 5.10 defines that the contractor will confine their areas of work to the areas permitted by laws and ordinances and the construction documents and what's written in section 1.3. So clearly you cannot block traffic for other people getting in and out of their houses, and you cannot unreasonably encumber the site with your materials and equipment.
So 511 provides that the contractor is responsible for making the construction all fit together, including where new meets old. Of course, matching new construction to existing is often part of a remodeling project. Not always, but as it says, where applicable. You may need to match an existing drywall finish. You may need to feather in new wood flooring to old wood flooring. Whatever it is, the contractor is responsible for matching the quality, performance capacity, and finish of existing adjacent structures or finishes. The contractor must keep a clean job site. It's not reasonable for an owner to, and this sometimes seems to be something that owners, it gets to the owners when the job site's not clean, but it's not reasonable for an owner to expect a spotless job site every night. But the contractor must keep the site, quote, free from accumulation of debris and trash related to the work. And at the end of the project, the owner can expect to not see things left behind like scrap lumber, bricks, mortar, sand in the lawn, etc. Next. So the contractor must also take reasonable precautions to prevent damage to, of course, the people, to the work itself, to the neighboring property. This is all in the contractor's control, so the burden is on the contractor. You know all the ways that people can get hurt on job sites. You don't leave laying around boards with nails sticking out of them. You put temporary railings around stairwells, etc. These are all reasonable precautions. The contractor also knows best as to requirements relative to hazardous materials. For example, lead paint being a very common one. Accordingly, the contractor is responsible for compliance, but the owner is responsible for paying for compliance, as is appropriate. So changes, there are always changes. 6.1 provides that when the owner and contractor agree on changes in the work in writing, they become part of the contract documents. though in writing is important. We know that in this type of work, there's a lot that happens that's not in writing as a practical matter, but you should try to make a practice of putting it in writing so you're not vulnerable to the idea that it was never agreed upon. But if the cost of the change is an issue, the parties can't agree on it, which sometimes happen, the contract provides that they can agree to keep moving forward, and later they'll calculate the cost of the change as actual cost plus overhead and profit. 6.2 says that when surprises are encountered, ones that couldn't be anticipated, the owner bears this risk, and that the contract sum and time are to be adjusted to account for the surprise. That would also be an appropriate placement of the risk. So the owner's rejection of work is a difficult topic in this type of project. And undoubtedly, those of you who are remodeling contractors have experienced a client with unreasonable expectations. The agreement says the owner may reject work that doesn't conform to the contract documents, which makes sense when there's some objectivity to it. But many owners may not really know what not conforming to the contract documents means. When we drafted the A113, we had a lot of discussion about how to try to place some limits around the owner's right to reject work and maybe some objectivity to it. But one of the projects we work on, when educating the owner about what is reasonable is part of what an architect is supposed to do when one is retained. But here it's likely just the owner and the contractor, and that can lead to disputes. So we added in the reference to a standard to try to provide some guidance for the contractor to point to in these situations. This is your slides, not the actual text of the document, but there is a fill point where you can fill in things like some examples of guidelines you may reference are the NAHB's Residential Construction Performance Guidelines. I'm sure many of you are familiar with it. That document covers, quote, performance guidelines for most of the various trades. Much of it is what we call tolerances. You can also get more specific and reference publications relative to different trades, such as the National Wood Flooring Association standards, standards put out by the Tile Council of North America, and there's many others. It may seem unnecessary until you get to know your owner better sometimes. Sadly, there are people out there who just cannot be made to be happy. And I think if you've had that kind of experience, you can see how it's important and can really benefit you to put in your contract up front some guidelines for implementing some objectivity into the process of determining whether work should be or should not be rejected.
Well, and there's a number of responsibilities that the owner has as well. First, they have to provide their site covenants, conditions, and the restrictions. And it's the responsibility of the owner to provide them to the contractor so that you can know what you are, what you need to deal with and what you need to comply with. It's also their responsibility to provide you with the homeowners association requirements and surveys. And then if easements or variances are required, the homeowner is the one that is responsible for that, for taking the initiative, for working through that and paying any fees that go with that. And then the owner is also responsible to provide decisions and information expeditiously. Next. So unlike some of the other larger documents that talk about the term substantial completion, this agreement just talks about completion in general. And it's defined as when the work is sufficiently complete for the owner to use. So that way you don't have to describe or define or argue about what does substantial completion mean, which in the commercial world is fairly well understood, but homeowners who've never done construction before, that may be a foreign term to them. So once the work is sufficiently complete for the owner to use that, then the contractor submits their list of items to be completed, or their punch list. And then the owner makes an inspection to confirm that list. And the contractor can complete those items. And then when the final payment is due, the owner inspects the work. And then the owner gives lien releases and other documents with the final payment. So termination, another one of those unpleasant things to talk about. It's still important to memorialize how the termination happens and address that so that both parties are protected and also receive what they're due. So if there's termination that's no fault of the contractor, the owner, let me start that again. If not at the fault of the contractor, the owner fails to make payments, the contractor can, after 7 days, terminate the contract with written notice. And then the owner is still responsible for paying for the work that was executed and reasonable overhead and profit, and any other specific costs that have been incurred for termination, such as materials that have already been purchased. Now, if the owner wants to terminate for substantial breach of one of the provisions of the documents, they can. But one of the things that's specific to this, so like some of the reasons would be if the contractor refuses repeatedly to supply enough properly skilled workers or materials, or fails to make payments to subcontractors for the materials and labor in accordance with the contract agreements with the subcontractors, or repeatedly disregards laws, ordinances, and rules and regulations of the authority having jurisdiction, or if the contractor is guilty of substantial breach of one of the provisions of the contract. So in this case, it would be a termination for cause, and the owner is entitled to finish the work, and then the balance due to the contractor is determined by how much is left of the contract sum. So let's say the project was a $100,000 project, and $75,000 had already been paid to the contractor, and it cost $20,000 to complete the rest of the work by the owner. That other $5,000 would go back to the contractor, because that would be the amounts paid that they had completed by the fact that the whole thing was completed for the overall price. Next.
So we've been talking about this A113 contract and using it as a vehicle to show you how important things that should be included in your contract up front, and we think it covers those things very well. But the A113 is part of a suite of documents that AIA created in the last few years for residential projects, and here you have 4 other documents that may be relevant to you. The first have to do with a custom residential project where an architect is to be retained. Typically, we're talking about a more involved project than one for which the A113 is appropriate. Of those first 2, the A110 is between an owner and contractor. The B110 is between the owner and architect. And then the last 2 contracts listed are for where there's just an owner and a home builder / contractor. The A111 is between the owner and home builder when the design comes from a third party. And the A112 is to be used when the owner and home builder are working on a design together. The home builder provides the design to the owner. So these may or may not be useful in your work, but we wanted to show you that the A113 is part of a group of documents that can be helpful for this type of work. And how you would get these documents. AIA offers many contracts beyond the ones we've mentioned. They also offer project management forms you've likely seen, including payment applications, G702 and G703, change orders or certificates of substantial completion. And there are three good ways. I used to buy all these, have to pick up all these at the local AIA storefront, but nowadays it's almost all online. It's hard to find them by paper, in the paper form, but there are three good ways to get them online. All these documents. You can obtain a single document, this basic single document, where you can edit only the project data and fill in the blanks, so to speak. The blanks, name, address of your company, of your project, name of the firm, etc. You can obtain a single document where you can customize and edit the standard provisions as you see fit. If there's some language you just want to make different for this project or in all your projects. Or if you use a large amount of documents, you can get an annual subscription where you can obtain and edit whatever you want. Next. And AIA does have for you many resources that are related to the contracts that they put out. You can go to these web pages, ACD Learn and ACD Help. AIA also has a growing set of educational videos on YouTube. You can Google that phrase right there and find those. And they also have a terrific team of folks ready to help you with either type of question you might have. If it's content related, you contact DocInfo at that email address and phone number. If it's related to the technical side of obtaining and using documents, you can go to tech support, and that's their contact info there on the screen.
And with that, I want to thank you all